Good morning, viewers, and welcome back to the Tobago Updates morning show, coming to you here live from the Port Mall in Scarborough, Tobago. We're just at about 7:07 p.m., and we get the conversation started this morning with Max James. And this morning, he's here in his capacity as an industrial relations consultant. And we're speaking to the most recent happenings coming out at TADCO, where there is the current situation of contracts coming to an end, an indication that positions will go up again for an opportunity where workers will have to reapply for those positions for consideration come the end of this contractual period. To give us his perspective on that, we have on with us Max James, Industrial Relations Consultant. Good morning to you, sir.
Good morning, Julien, and thank you for having me.
All right, so we want to start off by beginning to put things into perspective. How do you view this from the eyes of your experience as it relates to industrial relations?
Well, let me see. Let me just pull up my right. Good. So let me first say that you may not like what I'm going to say, but whether you like me or not is a question of what the law says, and I think that the executive council, I don't think that they've been properly advised. In fact, I believe they've been misled. Um, I don't even think the matter, I stand corrected, that the matter would have come before the executive council because it's a public matter, but we did not hear of it. So we can only go based on what we have heard. And there's only one hurdle this matter has to overcome, and that is whether there's an overriding public interest. But we will deal with that in a few more seconds. The question is whether the action taken by the board led by Mr. Ricardo Alfred, Andrew Cowan, and his team, and all the indications are from the general purport of the letters of dismissal, because they in fact dismissals based on the industrial relations matters. Now, there are some lawyers who might be advising the executive council, and they're all wrong. They're not industrial relations experts. They haven't studied industrial relations. It's not a matter of law, but it's a matter of industrial relations. It's quite different to law. And it's a matter also of good HRM practices. So where the industrial relations might be insufficient, then you have to go to the HRM, human resource management. And that's what we've been trained for. So it's not a question of law. So I want to dispel for the public what the industrial case is. Because some people, including lawyers, they believe that if you have a contract with a finite end, that you are not supposed to be re-engaged. The law says differently. So I want to bring to the attention of everyone listening and who might be reporting on it. Here is what the law says. So simply put, there's a legitimate expectation on the part of workers that at the end of their contract, they are supposed to be re-engaged. Some people say, no, but you have a contract. It says it's ended 23rd of January. The law says, no. So here's what the court has to say. And it's a Commonwealth case. Various authorities are of the view that a reasonable expectation renewal can exist even though the written contract of employment expressly stipulates that the employee fully understands that he has no expectation of the contract being renewed. So despite that, even there's a clause in that says so, we the industrial relations people say no, because you are going to put somebody out of employment and put them on the unemployment line. But there's a different pathway to achieve that, which is the HRM process. The HRM process is supposed to work. That's why we went to university to study this thing. So firing is not the option. Reconstructing a company is not necessarily the option. Here's what the law continues to say. Although the terms of the contract in this case, and that is a particular case, I won't go into the long citation of it, the court held that assurance given to the workers outside the agreement clearly conveyed to them that they could entertain such expectations. The employer basically overruled his own agreement. Meaning, so if you tell me that you'll retain my services, and the workers were told that their service would be retained by letter. So you move me from a permanent position, where I was on contract of service. We don't have time to go into all of that this morning. And then you put me on contract of service. That was the first wrong. So the company did that. They took the workers, say we will retain their services, and immediately put them on contract, which is a industrial relations wrong in the first place. But we kept quiet, even though we would have advised certain persons. This is not the way to go. The problem the employer faces with fixed term probation is that it creates the impression that the employee will be permanently appointed if the employee performs sufficiently during the probation period. If the employer did not address poor performance during this period, it will have great difficulty in arguing the substantive fair reason for the non-renewal. So what this is saying here is that you put people on probation, you have a performance management system in place, a performance appraisal system in place, and that is what all employers are supposed to do. Without that, how are you going to convince the court that you did the correct thing? And I can tell you, the court doesn't look very nicely. They take a very dim view on matters like that. So let's go to the...
Now, just before you go on, I want you to be able to respond to now the chairman for TADCO has indicated that this is not a dismissal. When we interviewed him yesterday,
he doesn't know the law,
he indicated
Julien,
that this is not a dismissal, but
what?
rather this is the end of a contract. How do you view it from where you sit?
The court says no, you are supposed to re-engage the person.
So there's a legitimate expectation for re-engagement, and
on every contract,
and that is on the basis that the persons would have been employed for an extended period where the contracts almost renew automatically, as has been the practice here in the Tobago House of Assembly.
Right. So let me just go back again for the benefit. Here's what the court is saying. The courts are saying. Right. Various authorities are of the view that a reasonable expectation renewal can exist even though the written contract expressly states or stipulates that the employee fully understands that he has no expectation of the contract being renewed. So court is saying, even though that is in your contract, peradventure it was there, and it is not there in these contracts, then you have to re-engage the person. The only way you will not re-engage the person, there are two grounds, because it appears that the matter is going to an injunctive state. So I don't want to go into the wherewithals of the particular matter. But the court is saying you cannot do that. Well, let's go to an international case from the level of the International Labour Organization, whose judges are drawn from the Privy Council. So we could safely call it a Privy Council judgment, right? So the chairman, as far as I'm concerned, I like being a little bit controversial. He's a beast. He doesn't know industrial relations. He knows marine engineering. He's the wrong man for the job. And he has misled, and his colleague, Deputy Chairman Andrew Cowan, so Ricardo Alfred, Andrew Cowan, and the rest of the board have misled the Executive Council. I firmly and sincerely believe that the Chief Secretary did not know and did not understand because he was misled. He entrusted a particular function, or they entrusted a particular function to this chairman and the board. They did not bring all the information to the Executive Council or the line secretary. So here what the international case says here. An international organization has a duty to inform a staff member in advance about the non-renewal of his or her fixed-term contract to enable the staff member to exercise her or his rights and take whatever steps he sees fit. It doesn't stop there. even where this is judgment 3368 of the International Labour Organization Administrative Tribunal in 2014. Even where a provision contained in the contract of the staff member or in applicable rules, beg your pardon, states that notice need not be given. So even though you say, I don't have to inform you, the ILO is saying, no, you must inform me. But you can't inform me 8 days before, because you have staff members informed yesterday, and you give me 8 working days, business days to exercise them. Where's the organizational structure? What are you saying? Okay, so Alfred comes in here and tells Tobago he thinks we are fools. The law doesn't operate so. Let him go and practice marine engineering elsewhere, but not in the public space. The law is clear that you must give people time to exercise the options. But the law is saying even before that, you are supposed to re-engage. So we'll prove that in a minute. Let's go down to judgment number 3090. The long succession of short-term contracts. So they were using short-term contracts because they didn't want to employ people and keep them engaged. So they said, we'll break your contracts. The court says, no, you can't do that. So I'm putting employers on notice. So even though you feel that you could put people in short-term contracts and break them, and the court says no. The court is saying that over the period of 7 years, this would have happened. So she took the matter to court. It reached to the level of the ILO. And it is saying that the employer committed an error of law and misused the rules governing short-term contracts. So you have to be very clear as to what you're doing when you're saying you don't want to renew someone's contract. It is a general principle of international civil service law that there must be a valid reason for any decision not to renew a fixed term contract.
So indicating that there's the need to restructure is not sufficient.
Depends on how you're doing it. That's the trick. That's why you have to rely not on lawyers who are they will misguide you to make money, and they're misguiding you under the guise that we are lawyers. Lawyers don't understand industrial relations. They'll charge you and bull rush you, but to make money and to big up themselves, but they don't understand. So here's International Labour Organization is saying that there must be a valid reason to not renew a fixed term contract. If the reason given is the unsatisfactory nature of the performance of the staff member concerned, who is entitled to be informed in a timely manner as to the unsatisfactory aspects of his or her service, the organization must base its decision on an assessment of that person's work carried out in compliance with previously established rules. So what that is saying, if you don't want to renew my contract, you have to base it on my performance. What are the non-performance or performance indicators that the board of TADCO put in place? You had 2 years to fix it. And then you're telling me that workers are unproductive. So fix it. You can't come now and say we will let go everybody. And the tricky problem is that who is going to, as he says, pick back workers? Who is it? Ricardo Alfred, Andre Cowan, the rest of the board, the CEO? They are not positioned in an organization to do that. That will be administrative corruption, because where you have a chairman, a deputy chairman, members of the board, and a CEO they will pick back workers. So here's the problem: you haven't shown an organizational chart. You haven't set any rules of engagement as to how that process will take place. And he said, you want to be fair, everybody must know when they want to be fair. Bull rush. He doesn't have a clue.
So what I want to get clear.
So you can't, as a chairman on a board, send home everybody. So who is going to re-engage persons? That's the question. That's the lynchment issue. Who is going to re-engage it? The chief administrator, she can't come down and do that. The administrator of the division, they can't do that. The board, they can't do that. So he has shot the executive council and the line secretary in the feet. He has given them no option than to remove the board, because the board can't go on, as we say, pick back the workers. What would be the criteria on which they will base their picking.
So the
So
question.
it must be unfair.
So-
and the courts take a very dim view on that kind of a tyranny that he has unleashed on the workers of TADCO and on Tobago in general. And the Chief Secretary, I would believe him that he did not know. And if he did not know, then he was misled. And if he was misled, he must remove the board. He has no other option. Because I believe him, he's a sincere gentleman.
So I hear you.
He could not have known and allowed that to happen.
Right. I hear you in terms of the course of action specific to the Chief Secretary and the Executive Council, if in fact they were misled under the circumstances and didn't have all the relevant details. But my other question rather is, what are the immediate options available to the affected employees in this
So I'll
in
give
this
you that.
circumstance?
I'll give you the two quick cases and answer that very quickly. The complainant impugns that was a matter again to the.
And that's if this matter is not corrected.
Yes. So this is a matter went to the ILO again. ILO is the highest decision-making industrial relations in the world. And their judges are drawn from the Privy Council. I'm just reiterating for the benefit of the public. So you can say it's a Privy Council judgment. The complainant impugns the decision not to renew his appointment following a restructuring, which entailed the abolition of his post. The question remains as to whether restructuring was the real reason, and I dispute that restructuring is the real reason, that Mr. Ricardo Alfred, Andre Cowan, and et al. It could be. It's a question of efficiency or inefficiency that they claim. So what they did was to give chickens and feed to the farmers. The initiative didn't work out because well managed. You buy back the chickens from the farmers, and then you have to sell it very costly because it was a foolish initiative. And then the public saying the cost of that is too high, so I ain't buying. So the chickens on their hand. Thousands of chickens and pounds of chickens and birds are spoiling. So who are you going to blame? The workers for that? That was your policy.
So in your opinion,
So you can't, for lack of a good policy by the board, and then say the workers are inefficient. Again, I'm saying to everybody, human resource management is the better route when workers are delinquent, if you believe so. So you put your performance management systems in place, you put your performance appraisal system in place, and don't. So what are you going to say to the woman who has 5 children that I'm now unemployed, and she goes sit down and watch them in the face, she let the children in the face? And where Andre Cowan and Ricardo Alfred sit nicely, the chairman, the chief exec, I'm going to put this out into the public. The chief executive officer of TADCO draws more than $45,000 a month on a company that's unproductive. $45,000. The next manager is $29,000. The executive council met that, and they should have taken action. They now have an opportunity not to send them the workers, but to remove the CEO who is working for more money, or just as the same money as the chief secretary, more money than secretaries, on a little company that is highly and grossly inefficient and unreliable, ineffective, and every other adjective you could describe. How are you justifying to the public that a CEO on an unproductive company is drawing $45,000 plus perks? He's the chief secretary or what?
So this arrangement would have been in place.
That's a P&M arrangement.
We heard yesterday that the former chief secretary, Mr. Dennis, speak to the fact about bringing together the companies amalgamate in order to form this operation. Are you saying that when this operation was formed, it was formed with that kind of salary range for the persons at the helm?
Yes, that was under Patlin Titus and they. She brought in Salazar, Denisio Salazar, paying him 40. That is not the TPP or PDPs, whichever you want to call it, decision. That was a P&M decision. Those are the facts. So they were paying him that. The chief secretary met those things. And I'm advising him to deal with that. You pay the CEO, you fire him because he's been overrun by the chairman and the deputy chairman. You fire him or you pay him towards the end of his contract, which I understand is coming to an end, and put a caretaker general manager in place until you could figure out what to do with the company. But certainly that kind of thing that is happening there, the chief secretary, and I am saying chief secretary, you need to act, and you need to act promptly You will have my support, but you need to act promptly and to end this craziness that this board that is in place is wreaking in Tobago. It just can't work. It is wrong. It's a waste of public funds. You can't be paying a CEO $45,000, more than a secretary, more than his own line secretary, more than the administrator for the division. It just didn't make sense. But that was a P&M decision. Of course, it's they who put that system in place. Nothing was wrong in bringing the three companies together, but this thing has to be fixed. And it can't be fixed with that chairman and that board, who the chairman overruns. He's a Boris Cess guy, Ricardo Alfred. He knows nothing about industrial relations, nothing about human resource management. He's a marine engineer. This is absolutely wrong. I cannot support it. The chief secretary and his team are sworn to uphold the constitution law without fear and favor. And if that is wrong, they must fix it. If they were misled, they must fix it. I can't believe that they knew and that happened. I don't believe they knew. Now that they know, they must act and act fast, because this thing is headed to the court. And finally, Justice Addison Khan, this is what he ruled. People were engaged on 2-year fixed-term contracts. And in what he says, a worker who serves an employer pursuant to a fixed-term contract is a worker within the meaning of the Industrial Relations Act, unless specifically excluded by law. Further, it is well settled, and this is for everybody to hear, those bush lawyers outside there who are advising the chief secretary wrongly. Let me know your number and give me your number. It says here, a failure to renew a fixed-term contract upon its expiry can be a dismissal, which is harsh and oppressive and not in accordance with the principles of good industrial relations practice.
All right, so we got to leave it there this morning, but this is a very strong and a firm call coming from Max James, Industrial Relations Consultant, calling on the Chief Secretary to act immediately in treating with what he certainly describes as a wrong in the circumstances, and that is the coming to an end of the contract and putting back out of positions where employees have the option to apply again in the circumstance. He's certainly not supporting that under the circumstances and calling on the Chief Secretary to act immediately. Thank you very much, Max James, Industrial Relations Consultant, for joining us on set here this morning. We also want to remind you that this is your opportunity to share the live, share the live, share the live. We'll be right back.